You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 116. What is patent litigation discovery? My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. Now, I've gone over the basics and chronology of a patent litigation lawsuit, and in today's episode, I'm going to be going over the part called discovery. Discovery is probably the most expensive part of litigation. It's where each side is trying to discover information from the other side, and this information can be written or oral, or it could be producing physical objects. Now, why is discovery important? One side says that you were infringing their patent. And one thing you might try to do is invalidate their patent because maybe they sold or disclosed their information before filing a patent application. So you're going to want information on when they sold it, what information they were aware of when they filed their patent application, who the inventors are, because maybe the company left off some inventors, which maybe can invalidate their patent. You're going to want to know a lot of information. So let's talk about some of the basic things that happen in discovery. The first thing is called initial disclosures. Initial disclosures are in the Federal Rules of Civil Procedure, Rule 26A. If you want all the details, you could look that up. In the initial disclosures, you provide information on some basic things, such as who might the potential witnesses be. You have to provide addresses, phone numbers of each individual likely to have discoverable information. This might be the inventors, might be other people that work at the company or the CEO, or just other people that have information that would be relevant to the case. You have to provide a copy or at least a description by category and location of all the documents and things that you have in your possession that you could use in support of your claims or defense. You have to provide a computation of each category of damages. You have to provide any insurance agreement that you might have that would be used to pay any damages if you lose the case. There are lots of exceptions on what you need to provide because some things might involve trade secrets, business secrets, or emails to your attorney, which of course the other side would love to have, but that's privileged information. So lots of times there's a fight when one party doesn't want to give some information, and a judge has to decide whether the other party has a right to that information, or maybe they could have the information, but it will be under a protective order, so only certain people from the other side can see it, and it won't become public record. One of the main types of discovery tools is called a production request, or it's called a request for production of documents. You probably want to see the other side's technical information about their products, marketing information, finances, minutes from meetings. You want to know whether there's foreign litigation going on. You probably want them to send you any physical products of the invention. There might be emails between company members that are relevant. Requests for production of documents are probably the main thing that you want to see that's going to help build your case. Then there's something called a request for inspection. These aren't as common, but let's say that what you want is just too big for them to send you. Maybe the infringing item is a boat. You can't just say you want them to send you their boat. You could say it, but you're not going to get it. But what you can do is you can request to inspect the boat. Then there's a discovery tool called Interrogatories. These are written questions that you send to the other side. These are answered by the attorney, but the attorney is going to ask their client for the answers. The questions are going to be regarding key issues in the case. If you are the plaintiff, you probably want to know when the defendant first became aware of the patent. Provide and identify any products sold that practice the patent. If you're the defendant, you're probably going to want to know when the patent was, when the invention was conceived, when they first disclosed their invention to others. You want them to identify any knowledge of any prior art. All sorts of questions you can ask them. Then another discovery tool is called a request for admission. These are questions that the other party can answer by saying admit, deny, or they lack the knowledge to know this. Now, one thing you want to do is just have everyone agree to certain facts. You might say, admit that you sold product X on Amazon, or admit that you are the owner of patent X. These things might not be in dispute, and it's just a lot easier at trial if everyone decides to agree upon certain facts instead of trying to prove everything at trial. If you're not going to fight about it, you may as well just admit it, but you also don't want to admit things that maybe would hurt you later, So you just kind of have to be careful. Hopefully your attorney will guide you through that. And the attorney is going to be the one that's answering these. You might have other things that you want them to admit. Let's say admit that the photograph attached is a photo of the product that you sell. Admit that, this is a screenshot of your website or something to that effect. Admit that your product has a curved base or whatever it is that you want to get on record. You can request them to admit that they're infringing your patent, but they'll probably deny it. Otherwise, why is this case going to trial? You'd probably just settle early on. You can ask them to admit that they sold a product before January 1st, 2020, or whatever date you think is important to your case. You can request admissions just to lots of different things. Another discovery tool are depositions. Depositions are oral testimony, and really anything you want to ask during trial or information you need from an individual at trial, you're going to want to know those answers to the questions before trial, and you ask these in a deposition. Depositions are when you bring someone into a face-to-face meeting. Nowadays, you can do a video deposition. It's usually in a law office. You have attorneys on both sides. You might want to bring in the inventor or the CEO or different kinds of people that are party to the case. And you can usually question them for about a day to find out the information that they know. But what if you have questions for people that aren't parties to the lawsuit that might have information that you're interested in? Let's say that someone sold some patented product to another company. Perhaps another company didn't do anything wrong, but they're going to be a witness to sales of this product. So you would have to subpoena them and maybe do depositions on these third parties. Or these third parties might have information about how much they pay the other company to buy the infringing products. A subpoena is used in order to force these third parties to give you information. Another discovery tool is expert discovery. You want to call in expert witnesses that are going to provide technical opinions to a lot of different things. One might be a damages expert, so they'll have fine experience in finances. One might be a scientific expert, and they might give an opinion that the invention was obvious, so they never should have gotten a patent. Discovery can get very expensive. There can be literally hundreds of thousands of pages, maybe millions in certain kinds of cases to review, and you have to question the witnesses. You have to pay experts for their opinions. The litigation costs can often be more than the damages are in a case, which is why even if you're right, you might just want to settle early so you can avoid an expensive fight. And that's the basics of what goes on during the discovery part of a litigation matter. If you want help with your patent applications, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's at DIAMENT patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.